Good afternoon, viewers. My name is Amitabh Singh, and I will be the moderator for today's webcast. Today's episode of IFA-India's Academy's monthly update on international tax and transfer pricing. As you may already know, IFA-India Academy is a part of International Fiscal Association, India branch, and has been following the international developments in international tax and transfer pricing very closely, and in its attempt to disseminate the knowledge about these two aspects on a regular basis, it has started the series of webcasts. We hope to do it on a monthly basis, wherein we will invite experts in these two areas and discuss events, key developments happening in the areas of transfer pricing and international tax. So in today's episode, like last time, we have two eminent tax experts. They on their own need no introduction, but I will still do that for me. Facing me is Vijay Iyer. Vijay Iyer is a partner in Ernst & Young. Welcome, Vijay, to the show.
Thank you.
Vijay is a veteran in transfer pricing in the sense that he's been part of that practice since transfer pricing laws came into the country, if I'm not mistaken. And he heads the transfer pricing practice for Indian practice of Ernst & Young. So welcome, Vijay. On my right is Mr. Rahul Garg. Rahul, welcome.
Thank you very much.
And Rahul is a senior partner in PricewaterhouseCoopers, and heads the direct tax practice, if I'm not mistaken.
You're absolutely right, as usual, always.
So Rahul, direct tax practice means it includes the entire gamut of corporate, domestic, and international tax, right?
Yes, that's right.
So thank you, and we have a high-powered panel today and many topics to discuss. So without any further ado, we would like to get started. But before we start on the listed topics of today, I wanted to give Vijay the speaking slot beforehand, because he's got some breaking news to share on the area of transfer pricing. So Vijay, why don't you share it with us in a very brief snippet?
Thank you. Yeah, so the most interesting development last evening is the new Maruti Suzuki Delhi High Court order in the context of advertising, marketing, and promotion expenses. So just to give a background, multi-crore litigation is on in the context of A&P expenditure, where the tax authorities have taken a view that expenditure done in India creates benefit for the foreign company, and therefore there should be a compensation paid by the foreign company to the Indian subsidiaries or Indian ventures. In this context, we had a High Court ruling in the case of Sony Ericsson a few months back, and in that order, the Delhi High Court had held that such expenditure made in India is in effect a transaction. And then they went on to analyze as to why the adjustment has to be computed in a particular manner, and why a set of companies should not be subject to the adjustment while others should be. And the broad contour of that was that if you are making sufficient profits at a net margin level, then you probably don't need to suffer an adjustment. However, the Delhi High Court in the case of Maruti Suzuki took a different view. They said that so far as Sony Ericsson is concerned, in that particular case or the cases that were held at that stage, the taxpayer themselves had offered that advertising and marketing expenditure is a transaction. Whereas in the case of Maruti, there is no such admission. At the same time, the tax authorities have not been able to prove that there is some agreement, arrangement, or action in concert for there to be a transaction. So in the absence of any such written or unwritten agreement, there cannot be a transaction. Further, they said that merely because you have expenditure in excess of what a few other companies have spent, that cannot be the basis to ascertain that there is a transaction. There has to be an agreement or arrangement or action in concert for there to be a transaction. And therefore, since there was no such evidence on record, Maruti Suzuki is free to spend as much as it wants on advertising. And further, they also got additional comfort from the fact that Maruti's profits were about 11%, which is far higher than that of the comparable. So on the whole, they said that there is no further discussion required in the context of advertising and marketing expenditure. If you don't admit it to be a transaction, if the revenue doesn't have any evidence to suggest that there is some arrangement, and if you were to have sufficient profits in your P&L, then you can be scot-free. So that is the sum and substance of where we have now reached in the context of this issue.
So it has taken into consideration all the prior judgments and then has come to this finding.
Yeah, so they had reasons to deviate from Sony Ericsson.
Right.
One is, of course, the admission of transaction. The second was that Sony Ericsson was a set of cases which were distributors, whereas Maruti represented a set of cases which are manufacturers. So they said that ruling per se does not automatically apply as a binding precedent. So they can relook at the facts and come up with a new conclusion.
So if and the court said that this is not an international transaction at all,
Yes.
to be benchmarked or looked at it from that perspective.
Yes, because of the definition of international transaction. So it has to be an agreement or arrangement or action in concert for it to be a transaction.
Okay.
In the absence of which, you can't assume it to be a transaction.
So they said it's not even a transaction, leave aside the international transaction.
Yeah, it is an expenditure done
It's
for
an
my own
expenditure
business.
done for my own business.
Yeah.
So there isn't a concept of transaction
Yeah.
because those three ingredients of the transactions were missing altogether.
So if I am doing a transaction for my business, but which incidentally, maybe remotely gives any benefit to a related party, the court is saying that you should not make any adjustment on that sort of fictional basis. Is
But that's a principle which is all discussed in past also in terms of the allowance of the expenditure incurred wholly and exclusively for purpose of businesses. And there have been numerous circumstances where the expenditure incurred incidentally gives the benefit, and in some cases not incidentally but by design give the benefit to something else, somebody else. And this is case in point from Supreme Court in Vishwasarya rice mill, where the roads were built at behest of the municipality, but it gave benefit to everybody who was locally having the factory in that area. And the court did say that, look, if it is incurred wholly and exclusively for my business, then even if it results in a benefit to someone else, and that benefit, is it incidental or is it deliberate, would not matter so long as it is exclusively for my business. When I incur as a businessman, I take a decision on that.
Okay. So it means that the assessing officer cannot disallow it as being excessive and unreasonable on one ground under domestic law provisions, and now there being no admission of any agreement being there. And I stress on the word admission because there was nothing on record that was put in. So that closes the chapter on advertising and marketing expenses, or do you think this will further?
So I would just add, when we say admission, it's more a matter of finding of fact. I would rather say that the earlier cases started on a concession in favor of the revenue when it was asserted that there is apparently a transaction and we are looking at measurement of that. But here is the case where it went to the root of the matter and fundamentally first adjudicated and brought it to adjudication whether or not there is a transaction. So it's not a matter of just a thing that is being overlooked or being fuzzily dealt with. It was very specifically and deliberately dealt with, and therefore to my mind constitutes a good law.
So plus, of course, we have the Supreme Court where this will be agitated again.
Right.
And there is also a lot more of thought leadership around BEPS in the context of marketing intangibles. All of that will evolve. But yes, the reading of the law is what it is. And if that limits the power of the tax authorities to examine this, then that's the way it will be, unless there's an amendment in law.
Yeah, amendment is a good point. We are at the threshold where the budget 2016 would be in the works. And one of the things they do is make a list of all the judgments which have gone against the revenue and use that in the drafting. So I think place to watch, but ANP has been something which has attracted attention of most international FMCG and brand-oriented companies. So very well. So now, with your permission, to our key topics, and of course, POEM, place of effective management, is the one which has attracted a lot of discussion and debate when it was made part of the statute. And I believe that 2015-16 fiscal year is the first year when this is already applicable. There was some talk that the government would be releasing the guidelines any day, and we were hoping, but as of going to press today, nothing has happened. So, Rahul, to kick off the discussion, one of the key things which has changed is Section 6, which talks about the residential status, has undergone an amendment. And typically, residential status and accrual of income, these are some things which are go to the root of a taxing statute. So why was there a need to change such a settled item, I would say?
So first of all, just realize that the test for residential status spans over companies and non-companies. And if you realize that what's the distinction between the two organizations as the businesses versus what's the distinction in the test for the two, and you find there is a key, very significant difference in the test that you apply for one than the other, whereas the businesses may be similarly organized. And why is that distinction which held field for so long? So I would rather say that there was perhaps a need to change it inherently in the formulation of it itself.
Right.
And when the formulation was done, particularly considering that there could be some sterling and UK companies who suddenly shouldn't become a resident in India, and to safeguard something like that, you brought in a concept for companies in particular, which was much more tight for somebody to become a resident while it is incorporated or managed from outside. So there was, to my mind, in beginning itself, a slightly back foot in terms of the determination test on this, which needed to be corrected, and therefore that correction is happening.
So it's actually not an amendment to change things. It's a much needed correction which you feel has happened now.
So I think the need for it is more felt when, as the businesses grew and maturity of economy is attained, more businesses becoming global, and more opportunity then becomes available to the businesses to do the transactions where you could easily carve out a portion of your business, a portion of your wealth, a portion of your investment, and portion of your income to be located outside of India. And then, in the absence of two things, there is no exit tax from India and there is no CFC regulation. So what it results in is a situation which is not highly desirable from a tax collector's perspective, because you then allow the income and the tax event to be shifted outside India. And this, as you saw in the amendment, was a anti-avoidance measure.
Right.
And that's why it finds place now, whereas it could have happened earlier, and I wouldn't have been surprised if it happened earlier either.
So one of the key departure, and I need your view on that, is instead of the commonly used Indian term of control and management, they have replaced it with the term place of effective management, which even in the memorandum they have said that that's a more globally recognized term, and there's been a lot of commentaries on that, and that's why seemingly they have used the term. Now, are these two terms different? Is one narrower than the other? What is how would the jurisprudence on this evolve?
So just to answer your earlier question, there is a guidance that is still awaited. In the absence of that, this can be a nightmare because you can always read into effective management the way you would like to. There are some sections of the Act which will define that, and there could be different interpretations of it, which can be even more dangerous. So there has to be a limitation to the extent to which you want to extend it, and it should be limited to an anti-avoidance kind of things, which was the reference the finance minister had made, where he said that there are probably shell entities which are controlled entirely from India kind of thing. So which we agree that merely by holding one board meeting can you just cut off the link with India. That should not be correct, which is very fair. But there could be active businesses which are run, and then you could interpret as to what is effective management and what kind of decision making would be permitted in India, what would not be permitted in India.
Mm-hmm.
So effective management as a phrase would be slightly more flexible than control and management, and therefore it brings in the essence of substance into it, and it could help you to argue that it is not necessarily effective management if critical decisions are outside. At the same time, if merely because you have the legal control and management sitting outside, it will not protect you from that.
Mm-hmm.
If your in substance management is being controlled from India. So I think it is a more widely known term in treaties, and it's applied across the world. So it's nothing new. But I think the implementation of this is going to be critical.
Mm-hmm.
And if we have to go forward with implementing some of the BEPS conclusions on CFC and things, we might as well revisit this concept, because this may not necessarily be required if you're going to look at passive income of CFCs to tax here,
Right.
and leaving the active income as it is. So that should be a good way to deal with it. But if you just say that decision making sitting in India will create residency in India, that can extend to a lot of litigation.
So that's the point which struck me, that now in the assessment of any foreign companies, or even if the foreign company is not an assessee as of today, do you think this will be the first sort of step in an assessment that, okay, show us where the place of effective management is?
So I would think that not in case of all foreign companies, but particularly, as Vijay rightly said, to look at the aspect of avoidance here. So if you have a 100% subsidiary, which is an investment company having passive income, no employees, only assets, return on income is of the nature which is more passive than active.
Right.
In those cases, yes, it would be the first question, that whether or not your residence is actually outside of India, but not in case of all foreign companies. So I don't think, particularly if you were to categorize it in two baskets, the MNCs who are based outside India, for them, is it going to be a great challenge? The answer most likely is no, it shouldn't be. And on the other hand, the Indian companies who have lots of active businesses overseas, that also is a category which to my mind would not get too impacted by it. It would be only that small subset where it's the passive income which is shifted or located outside India, whereas effectively the control is in India.
Okay.
Yeah. So it's a matter which, if you were to see it in its full amplitude, it could cover all sorts of things. But I think, given the background of it, and given that the minister made this provision amply clear that it is for anti-avoidance, that itself, even in the absence of guidance, gives a restricted application where it should go.
No, that's true. But as we have seen, and although the FM has been talking about having a non-adversarial tax regime, but minus the guidelines, do you think this is another weapon of mass destruction which assessing authorities will use? This question is to both of you, your individual views.
My own view is that with the new government change and with the change in the tax administration, and we see there is really an attempt which is percolating down even to the field level of reaching the stage, or at least moving in that direction of having a non-adversarial tax regime. So I think, yes, it is potentially a weapon, but I don't think it would be as rampantly used as would cause a stress on the businesses, or cause disruption, or impact the business climate too adversely.
So is this a new product that you're selling to your clients, to do a poem checklist?
It is an area of concern, especially for Indian headquartered. So they are worried as to what is the line that demarcates between their role as a shareholder, as a stewardship role, versus a management role, and that's not very easy to determine. And I don't think we will necessarily have a situation where there will be no guidance, because it is very explicitly stated in the finance minister's speech that they will clarify this. So we will have a status probably before we end up filing tax returns next year. But hopefully that should cut down the level to which this will need to be evaluated. But at this point in time, it is an area of concern, and there is conversations happening across various Indian headquartered companies.
So one question I had was that, is it possible for a company to have no poem at all or have a place of effective management in more than one jurisdiction? Vijay?
Yeah, so it is possible when I look at it, and that is possibly one of the ways to deal with it, where you say that effective management is a collection of various activities of management, and therefore there may be a decision making in regard to finance, decision making in regard to strategy for business. Maybe two or three of these things collectively may form what is management. And if they are over multiple jurisdictions, then you will not necessarily identify the place of effective management as very distinct from where the board is sitting.
Right.
So there will still be a board which will be the effective management, and you're looking beyond the board only if it is centralized at a particular location for most of these critical functions. So possibly a global CEO kind of role can create complexity if all of these smaller functions report into him, and you're trying to run these functions. So then you may say that maybe effective management still comes back to the CEO sitting in India. But if you have most of the functions spread out and direct decision making run with the board, maybe you are splitting the effective management into multiple jurisdictions. So it is possible.
So one thing I would add to what Vijay said, that in the current definition of place of effective management, the emphasis on the key decisions and the emphasis on the key decision which are key for the management of the entity as a whole. Now, in one way, if you were to look at in a company, how many decisions are such which are the decisions for entity as a whole, not qua an activity or qua a business line or a vertical of business. There are very few decisions. Maybe the decision of declaring dividend or issuing capital or appointing board or appointing auditor. There are set of decisions which you can see are the decisions for the company as a whole, as an entity as a whole, which are necessary for, and you cannot take them by business. You need to necessarily take them by entity as a whole for organization. Whereas the other decisions, by nature, you could take them business by business if you follow a decentralized business model, or you could still take them for entity as a whole if you follow a centralized business model. So to my mind, the determination of this is not only dependent on what organization structure you have for decision making, but also how you have organized yourself in terms of delegation of power, in terms of reporting relationships, and also in terms of how the outsider looks at you and how you're holding it out to the public, that what is my decision making power and where is it situated. And therefore, as Vijay said, that if you have a place of effective management at more than one place, is a possibility. On the other hand, could you have a place of effective management which is nowhere?
Yeah, that was a question.
Right. So if you have a place of effective management, if you say that it's a management of bare minimum these many decisions to be taken together, and if you can disaggregate that, and particularly I bring in the aspect of the current ways of work where you can disaggregate almost everything to as much granularity as you want to, and if therefore you have a measurement which is designed on this, that these 6, 7, 10 decisions must necessarily be together as collectively sitting at one place to constitute place of effective management, and then you disaggregate that, you could have a situation that in this current world there is no place of effective management given that definition. And that's why the point that Vijay made, that the aspect where place of effective management, should it be strictly defined, or is it better to retain the fuzziness in this? Maybe an aspect which is better to leave it fuzzy, but it is, to my mind, becoming more and more challenging if you leave it fuzzy, that in the new order of the world you may not be able to contain it, and therefore the disputes on this would arise even in these circumstances where there is an assertion of certain decisions being taken at one place, the certain other decisions being taken on other place, and the dependencies of those decisions, whether this was not taken, therefore you could have taken the next decision, and therefore how do you put it in the organizational structure would really become a big issue. And therefore today, if you look at the companies, most of the companies, and one of the things I see is what's the fallout of this. Most of the companies are relooking at their DOP, relooking at the workflows that happen in the organization, relooking at their IT systems, how they work and transfer, and who is taking final decision, and what's the documentation and evidence of that. So it's very clear that businesses would be undergoing
Mm-hmm.
a change in terms of meeting this, so that it's not only a matter of just making a decision but also a matter of evidencing that. And that's the effort which most of the businesses at this point of time are engaged in, whether or not guidelines are there, because it has started kicking already.
Mm-hmm. So you're saying that companies are taking it seriously.
Absolutely.
Yes.
And we used to hear companies, especially as Indian executives have climbed the global corporate ladder of multinational companies whose global CFO is sitting in India, or somebody has a regional responsibility.
Yes.
If Rahul Garg becomes the head of direct tax of the whole Pricewaterhouse Asia region, and he conducts that business in India, are we looking at some kind of loose cannonballs in the assessing officer? So you have said that the business has to be looked at a whole, but I guess this is a new area of dispute.
Yes.
That we are staring at, regardless of whether the guideline comes or not. I think the guidelines, even if they come, will raise more questions than answers.
To my mind, it is very, we would need to keep it simple and not necessarily depend too much on guideline, except for the things, as Vijay said, that guidelines may make it more apparent that on these class of things it should not apply. On the other hand, rather looking at the guidelines to say that on these class of things it should definitely apply. So exclusions is what one is looking at in the guidelines. But the people who need to take action today are mostly the people who are not falling in that category of exclusion. They are falling in the category of being included and being tested for this.
Yeah.
And it is in those cases where you are looking at revamping your organization structure, delegation of authority, and as you rightly said, the regional people sitting here in India and doing the regional role or Africa role, and particularly we are seeing more on the MNCs using the India as a hub for doing the business, not only in region, also in Africa, because they say that it's much better. And
Right.
those are the situations which need more attention.
Yes.
And in those situations, this disaggregation of the responsibility and the whether it is the regional role is a stewardship role, or whether regional role is a management role, or whether regional role is a controllership role, that classification is not fuzzy. It's very clearly defined in the corporate law. It is very clearly defined in civil law what's the role or responsibility for each one of those, and therefore it is possible to neatly bring it to table as to whether or not it evidences one fact pattern or another. Right.
No, I agree. And so what does it do to, say, transfer pricing? Suppose a foreign entity, company incorporated overseas,
Right.
is held to be a resident in India.
Yeah.
So does that mean that the transfer pricing regulations will no longer apply in terms of its transactions with an Indian enterprise?
Yeah. So then it's not an international transaction.
Okay.
So maybe one of the ways we are looking at it is to say that if there are companies which may potentially be with effective management in India, then can you just do away with transfer pricing there and admit a residency? So that could be a way to avoid the
So is
transfer
that an unintended benefit or a leveraging of
No, but it's too much of a pain. I don't think anyone would want to bite that bullet, because it gets into a lot of compliances for that resident, the so-called resident, and it's possibly not practically viable to do that. But that could be one of the possibilities if it's something where you can manage. So it would be an exceptional case where you can manage the logistics and the compliances of maybe a TDS compliance or any other advanced tax payments and stuff. Then if it's few transactions and you can manage it,
Right.
then maybe it's a good idea if you're not losing out on the tax arbitrage.
Okay.
But the point is that if you are held to be a resident, then if you are held to be a resident, it means it's a position the tax department takes, and therefore you would need to make that choice. Do you want to accept that position, or do you want to contest that position? And so long as you want to contest that position, then the plan B of not having transfer pricing or being treated as a resident, etc., that doesn't arise, right?
Yeah.
So making that choice at that stage, to my mind, would be very inefficient way of dealing with this. We need to make that choice proactively now.
True.
Right.
That choice should have already been made during the year. So, but isn't this whole characterization thing, looking one-sided? That if an Indian company, a company which is incorporated in India, has its control and management wholly outside India, it will still be a resident?
So I think you pose a very interesting question here. So what's happening is, as we rightly said in the beginning, that the whole thing of the residence as it is appearing is for anti-avoidance. And anti-avoidance of what? Of the taxes, right? Now, with the whole debate on the BEPS and looking at the taxing rights, not so much it is discussed as taxing rights in the debate for BEPS, but it is discussed more as a measurement criteria for income. But nonetheless, it gives you a situation where how much of the income then gets taxed in a particular situs or a location. So if you were to look at that, to my mind, this whole aspect of the place of effective management or even residence versus source would not have any relevance. Going forward,
it's where the economic activities are
so whether you measure it by value creation, you measure it by function test or any test, so long as your measurement criteria on that is robust, you would get to a regime where these things would become irrelevant in determination of what's the tax liability of a business in a particular jurisdiction. What would then become relevant is who gives the tax credit for what. And that becomes more interested than quasi state versus businesses. And hopefully, if there is a concerted action, we would not get into a situation where more than one state asserts the same measured income, but then they choose that I would also not give credit and you would also not give credit. That would be very distressful situation for the businesses.
Absolutely. Like, do we see more tiebreaker test type of things coming? Or say the US treaty where it says that if the tiebreaker situation ever comes, that DTA will cease to apply. So we will see these kind of situations also cropping up.
Yeah, so I think US is one example where there isn't the treaty altogether goes out of window, but there are other treaties where it provides that yes, you would resolve it through mutual agreement, etc. And I suspect that more and more of that would come into play when the overlapping measured income or overlapping taxing rights get into dispute because of residence. So far we have not seen so much of the MAPs on the residence issues, but when this happens, I suspect that there would be more MAPs on the residence issue where the treaty permits it to be taken to MAP.
Or could this also form part of that multilateral instrument which is being created?
I did not see this to be a part of multilateral instrument. They did, the BEPS report recognized this as an anti-avoidance thing, but I'm unsure whether it's.
So it was more on value creation and economic activities. Okay. So shifting gears now to another of finance minister's reform-oriented program, in which actually the I would say the nuts and bolts were put by the Kelkar committee. I think you had contributed actively to Mr. Kelkar's report on tax reforms, where he had very categorically said that have a lower tax rate and do away with all these exemptions and deductions. So I see a offer that I will phase the corporate tax rate over the next 5 years by 5% or so, and but I will immediately withdraw certain exemptions and deductions. Is that a fair trade?
So to my mind, one I would just like you to be a little more careful at that. It wasn't an announcement that we would immediately withdraw the deduction. So it was said that we would protect this, whatever is vested right, so the unexpired period would continue. So it's not that suddenly in one snap everything is going away, whether it is vested right or not. So
the gates are being closed.
Yes, the gates are being closed for you to entry. But if you've entered already, you can do your park and you can do everything that you like. So that's one point. But the other important point, and from a reformist point that you mentioned, is that today we are looking at a rate of 25%. And currently, the corporate India total tax rate, effective tax rate, is about 23.4%. Right. So if you compare the 23.4% today's rate with 25% rate on no exemptions, deductions, incentives, or holidays, then in effect, you are saying 1.5% additional tax on the book profits that everybody ends up paying.
Right.
So therefore, it is indeed a head rate that looks lower which is 25%.
Mhm.
And therefore, to my mind, the way to implement this would be to, like you're doing for indirect taxes, look at the revenue neutral rate.
Right.
What is the revenue neutral rate? And you can do that by industry.
Mhm.
You can say that for these kind of industries, this is the revenue neutral rate, and therefore we will scale it down and get to that revenue neutral rate so that businesses are not stressed. And this 25% benchmark is a benchmark which would have come from some calculation, and I expect some point of time public would know that how did we come to 25%. And in that calculation, if you find that we are converging to an effective tax rate which is no more than the tax rate today the businesses are paying, it's a fair deal, because it takes away lots of complications and lots of administrative issues and implementation issues in the tax act. But on the other hand, if it increases the overall tax burden, then one would need to see how much fair it remains then.
But let's look at the whole policy part of it. Are all these tax incentives or deductions have been given to promote or economic or a social objective, development of backward areas, promotion of exports, promotion of R&D, capital expenditure, so accelerated depreciation, weighted deduction for R&D. So are we over that hump yet? Now is India no longer in need of these kind of stimulus? We are moving through GST to one common unified market. Now, inclusive growth will happen minus any of these incentives.
No, I don't think the structure is zero incentives and 25%. I don't think it is like that. If it is so, that will be quite difficult to chew or accept, because there are still those social agendas or maybe sectoral agendas that we have. So you would still see some incentives flow beyond 2019,
17 or whatever, yeah.
19 beyond, 2019ish. So you would still find some of that happening. It will not be killed entirely. I think the discussion is to see what part of it can stay, what can go, what part of the industry has already matured enough to absorb the cost, and what are the industries which still need the support, and then selectively move some in and out, which does leave a scope for the negotiation and then getting into haggling every year in the budget process. So that issue still continues, but I don't think it will be a door closed for everyone and on a particular date. So that some of the social causes will continue to be looked at.
But there's another thing. What Vijay says is very, very instructive here, that if you leave a small window, everybody wants to fit in that window, right? And therefore you would have the advocacy, need to show that what's priority for the country, economy, etc., etc. That would continue to grow. And we have seen even in past that while this policy of phasing out the tax incentive was announced in many budgets, many years over and over again, still we used to have new incentives coming in, whether it was investment allowance, whether it was workers, whether it was lowering of the threshold for various things. So it keeps happening.
Yeah.
And therefore, for looking at this as a policy consideration, if it is driven from a perspective that incentives do not yield the policy objective, and there is a lot of literature on that from multilateral agencies and the economic institutions, that incentives have not yielded to that. And we have the situation in India where we have one of the most generous incentive on the power sector for last 3-4 decades. And the other hand, we had the reasonably generous incentive on the telecom sector, right? So, and if you look at the maturity and the growth of both stand on a very different pedestal today. So there is a feeling that perhaps the tax incentives don't necessarily yield the objective, which is social objective or a larger economic objective. And if that be the case, and if you want to then make the Income Tax Act as a tool for collection or generating or garnering revenue, then you are moving away from the incentive, not because you don't want to promote those sectors. You're moving away from the incentives to make the Income Tax Act as a pure tool of tax collection, and you can still keep funding those social causes through direct subsidy or targeted subsidy, etc., which means that the whole thought of using tax
as a tool
to disburse subsidy, that goes away.
Right.
So is that a good thought? Is that a good thought or not a good thought is a debatable question.
What is your opinion?
So in my view, today, until we have a very robust mechanism of identifying the delivery mechanism of subsidy to targeted audience or the targeted group, Income Tax Act provides one mechanism where it gets directly delivered at the source, at the point where it impacts. And therefore, it is preferable in the absence of a system of a targeted subsidy delivery.
Plus, it has its own monitoring through assessment and scrutiny. It has its own monitoring mechanism.
Which to my mind would be more fuzzy in income tax, because you have 3% of the tax cases being scrutinized today, less than 1% of the corporate tax cases getting scrutinized today, right? So the monitoring mechanism here, whatever exists, to my mind is not very strict. On the other hand, if you would have a direct subsidy disbursement, you would have much more closer monitoring and much more transparent view as to what it is impacting and to whom it is being given. Now, it's another issue whether it is politically right to do that.
Right.
Because this goes here in the income tax as a fuzzy thing, and therefore nobody knows who enjoys what kind of subsidy.
But there is a revenue foregone statement.
So even the revenue foregone statement, I don't know how much of our voters read the revenue foregone statement, right? Whereas if there is a targeted subsidy and a item comes that the allocation for hospitals or sanitation is X, and an allocation for the power plant is 16x, how would the voter look at it? Would be very different. So to me, the considerations to retain it in tax may not be a purist consideration of this being a more efficient system of delivery, or this being more useful or meaningful or impactful. It may be driven from some other considerations. But as a purist, I would agree with the proposition that you should have this act to collect the taxes and do nothing else. For anything else, you find the mechanism which are more efficient to do that.
So this proposal has public comment has been invited, and I'm sure as the two largest firms in this country, you would have also given your views on that. So if you could share maybe the top highlight of your recommendation. Is it good? Is it bad?
So in terms of the recommendation, as I said earlier, the one recommendation which is underlying every other thing that it manifests as a recommendation is that the ultimate burden on businesses should not increase, right? So it should remain revenue neutral. The second part of it is when we are moving to a system of no incentive or less incentive or least provision dealing with incentives, then as a contrarian, you believe that MAT would not have an issue, right? You would not need to have an MAT.
Right.
Our position is you may as well have only MAT, and you don't need to have anything else. Right.
Just tax on book profit.
Just tax on book profit, and that's the end of the matter. And you tax on book profit, your Income Tax Act of 600 pages would become 15 pages.
Right.
And MAT provisions have got a maturity over last 20 years, and there are least litigation on that. We did a research, we found that MAT generates a litigation of less than 3%, and the provision of computation and incentive generate 37% of the total tax litigation. So our recommendation on this is that if you're looking at this as a tool for collection of taxes, the government should also become a little more long-term view, because even if people argue that in the accounts you could defer something or you could prepone something, it's matter of only a few years, timing. And in an economic cycle for a business also changes, and you have so many economic cycle running industries, some of them are counter to each other, so it will get evened out. So if government wants to take a little long-term view on this, it's a great opportunity to phase out incentive, come to the book profit based tax, reduce your Income Tax Act, and deliver the subsidy for social causes or economic causes separately.
So
at least our conversations have largely been around at a more micro level, not necessarily at a macro transformation, but more at a micro level to say what part of this can go, because I don't think the intent of the government also is to make it zero incentives. Otherwise, the request itself would have not been required. They would have just amended the law to say no incentives and 25%. But they said what is possible, what is not possible, how do we phase it out? So in that sense, we said whatever incentives are existing, they should live their full life, which means that you will not get the benefit of removal of incentives right now. So let's say an SEZ which is set up, is in third year of operation, still has a lot of years of its incentives available. So it will not pay 25% for some time.
Right.
So you will have the problem because you have to substitute that with someone else. After a few years, it will start paying more taxes than it's paying today. Some companies, if they are going to end their incentives anytime soon, will jump to a higher rate.
Right.
Their burden will go up and they will have to absorb that. And that cost will somewhere subsidize some of these. So the discussions around phasing out what's the right timing, how to do it. And if you look at that, I think a 25% happening in a few years' time should take care of it. In the interim, maybe some of the incentives may be given some kind of a sunset clause and they'll be wiped out. And we don't bring in new incentives. That's the way we've approached it. So I'm not sure which way the government wants to ultimately implement it. But it doesn't seem like a full write-off of all incentives from day one.
So, and I agree that what I presented is a model and opportunity to the government. I don't think so there is enough radical thinking to accept that as such, and therefore in the interim the aspect that which one of these should continue for which industry group and for which class of the taxpayers is the discussion which is happening in terms of interaction with the government. That look, infrastructure is still very, very important. The IT may not be as
so there'll be industry groups lobbying for their own respective.
It's an advocacy for better and good of the overall economy, and I don't think it's definitely an aspect of lobbying to some extent involved in that. But yes, everybody presents what's my best case scenario and what's my best case contribution, and we help people do that. And in that, there would be a choice then ultimately somebody would need to make that, yes, if you want to move to this direction, something would have to be dropped and something would need to be continued.
It's true. My only fear, and we'll end with this question, is I remember, there was a sunset clause provided for STP units, and there was a virtual stampede on the last date of that financial year to register STPs, and immediately the next day those were for sale. So a lot of rent seeking and premium extraction happened. The moment you come to a gate closure kind of a thing. So I guess that is unavoidable. Yes. Anytime you close the gate, that will happen.
Yeah, so it is unavoidable, except that you may, from this experience that you mentioned, you may have the situation where there is again an anti-avoidance, or there is again a mechanism where this rent seeking is reduced or is mitigated to or eliminated to a certain extent. But yes, there would be always people who would take this as an opportunity to do so. But the positive side of it is that if you have a plan which is slightly long term, in this case 5 years, etc., and if it is discussed transparently with the industry, and this dialogue is very important, and the industry is engaging with the government on this dialogue to at least understand what's the time frame, how is it going to unfold, so that they can plan it well. And that's where we are assisting them to say that, look, you shouldn't get hit by this all of a sudden, and you must be able to accommodate this in your planning. And if you accommodate in this your planning, you would find other avenues to deal with this in much more effective manner.
Definitely. So we look forward to see how it pans out. I guess the government is in no hurry to come out with it'll take the recommendations.
No, but they're working very hard on it.
They're working very hard.
I think they are in hurry to showcase that, yes, they are on the path to reduce the effective tax rate.
On a daily basis.
So they're calling for meetings.
Yes.
Okay. I thought they will be busy now with the budget.
So it's a part of that exercise.
It's a part of that.
What can be put in here, what can be put next year. So.
Very good. Let's hope for the best. So moving on, we started with transfer pricing, and now we're back to transfer pricing, which has, I don't know how much percentage of the litigation today at the tribunal level is of transfer pricing, if your company has done some analysis, but the TCS judgment, once in a while there is a judgment which comes, which certainly makes everyone say, what happened? Where did this come from? And the crux of this judgment was that the reference to the transfer pricing officer should not be an automatic or a mandatory or mechanical exercise to be exercised by the AO or the CIT, but it should be a well thought out, almost like a reopening of an assessment, kind of a reasoned thinking. So tell us, in brief for our viewers, what exactly happened and what is the situation after this judgment? How seriously do you take this judgment?
So in 2000 and I think 3, the government came up with the regulation on what a transfer pricing officer is. So they started planning for the TP assessment. So at that time, they came up with a circular saying that how do you identify cases for scrutiny?
That's instruction 3.
Instruction 3, yeah.
Right.
So they said that every company which has international transaction in excess of 5 crores has to go through a compulsory scrutiny. And the way the law is worded is that the law says that the assessing officer shall evaluate, and if there is a reasonable cause, whichever way it's worded, then he shall send it to the TPO for reference. And then this circular came in which says that you shall do it if it's more than 5 crores. And then it also says that once the transfer pricing officer gives his order, the AO shall evaluate and decide what he wants to do with it. So in 2005, the first set of transfer pricing orders came out. And one such case was Sony India, where this matter was taken to the High Court to say that this order is not right in law because the reference itself was incorrect.
Right.
If there had to be a reasonable cause for the AO to send the file to the TPO, he should have documented it and opportunity should have been granted. And the instruction by itself takes away the right of the assessing officer to do that exercise. It forces him to give it.
Right.
So the Delhi High Court said no. Basically, because once it goes to the TPO, it comes back to the AO. AO has the authority to throw it into the dustbin and not follow it at all. Therefore, it is okay because then it doesn't take away his powers. He still has the powers. So that was fine. Thereafter, it was followed in the case of Aztec in the special bench in Bangalore. And the tribunal also said, yes, the power is not taken away, so reference is not an issue. Then the government did an amendment in law, and they said that whatever the TPO sends to the AO is bound to follow that.
Right.
Thereafter, so everyone realized that yes, now there is a change in the way things are being looked at, and now it is binding on the AO. So the earlier order of Sony doesn't necessarily apply, and has to be relooked at. But no one had really challenged it thereafter. Now the TCS judgment looks at it in more detail and says that effectively you have taken away the power of the AO. You're not doing the exercise of evaluating it. You're sending away all the files that meet a particular threshold, which is not as per the law, and therefore this is not acceptable. And since the order is binding on the AO, now the flexibility is also gone. So therefore, Sony court case doesn't apply, and now you have taken away the powers. Therefore, this reference is incorrect.
Okay, because now whatever the TPO sends, he has to mandatorily
follow.
Yeah. Right.
So that is what has happened now. But 2015, maybe a month back, we got a new guidance.
The instruction 13.
Instruction 13. So that now says that it shall be now based on a risk assessment by the AO, and opportunity will be granted. And now the AO has to decide, and there will be no 5 crores, 15 crores, nothing. AO will decide what to send, what not to send. And we are already seeing cases where there have been cases which have gone through assessment through transfer pricing in the past, adjustments made, potentially seen as high risk by the department. But the AO now says, I'm not going to send it to the TPO, I'll do it myself. So that's a new game that has started now, where the AO says, why should I send it to him? I can also evaluate transfer pricing. I'll also start figuring out what are the 5 methods, 6 methods. I'll look at case laws. I'll figure out myself. So don't worry, I'm not sending it to the TPO. So that's a new challenge that will start. But therefore, the TCS ruling has a limited applicability till 2015, and it is right what it says, and will be utilized in cases pertaining to the prior years. Maybe it will not be accepted for Delhi because of the Sony High Court order, but it is a distinguishing factor and can be distinguished. So the courts can take a view on that separately.
So if there are litigation which is going on and which are still open,
Correct.
do you think companies would try to take it as an additional ground now that there is this?
Yeah, it's already started.
It started.
Yeah. So especially in some of the markets where you don't have a high court against you, clearly it is open. And where you still have a Sony High Court, you can still go back and contest it.
Okay.
Because it is based on a prior law and not based on the current law. So that issue will start, and the whole discussion will start all over again.
And it's very important thing, as you said, that the people who did not consider it earlier worth challenging, should they now do it?
Yeah.
And can they now do it? And the answer to both of these things is yes, they should. because it's not yet a decision from Supreme Court, and if Supreme Court decides the matter in favor of the taxpayer, many of them at that point of time, few years hence, may not have an opportunity to do so. So to my mind, it makes huge sense that you precipitate this at any stage of your proceedings or appeal or even in court. And this being a purely legal matter, we have already rulings from the courts that a legal matter can be raised at any point of time, and therefore you would have an opportunity to raise it at any point of time. And many companies have started doing that. A lot of adjournments, you would say, people are saying that because we want to move an additional ground of appeal. Right, and then
or they are watching some other case and say, let's wait for that.
Yeah, so most of the people would not watch. Most of the people we are seeing and we are interacting with, they're saying that if there is an opportunity here, should I give it up? And
Right.
here there is no downside to it, right? If you take up this as an additional point, there's no downside to it, except perhaps it might delay your appeal a bit because there is an adjudication of additional ground, but that's an open and shut case that legal additional ground can be taken at any point of time. So
is it settled or almost settled that additional ground can be taken up at the tribunal stage for the first time?
you can take up any additional ground which is legal ground, which does not require, as the restriction was earlier in 111 ITR in Guzar Grover's case, that if it does not require investigation of the facts,
Right.
then you can take a legal ground at any point of time. And this was confirmed by NTPC also in Supreme Court. So that's
fairly settled.
Fairly settled.
Fairly well
Yeah,
settled.
fairly well
Okay.
settled. So even adjudication on this aspect of additional ground, I don't think would be much time consuming in the proceedings at the appeal stage.
But you made an interesting observation that the AOs are now trying to do the work of the TPOs.
Yeah.
So do you see this as a tussle of some sort between within the department, or does it make the TPOs almost redundant in the whole scheme of things?
No, so there are two things. One is that TP reference delays your scrutiny by 1 year.
Okay.
So at times you want to collect earlier. So you don't want to let the TPO sit on it for 1 year. You just pass an order right now. So
Okay.
you are able to create a demand right now. And if you believe that there is no rocket science, what this guy has done for the last 5 years, you can do it for the 6th year yourself. You might do it.
Okay.
So that is one driver to fast track the process.
Right.
And there is no particular binding reason for it. So he says that if I am authorized to do it, I'm allowed to do it. Why should I not do it?
Okay.
The other is also an internal feeling that why should this be an area for a few people? It's a tax issue. I can also figure out what is arm's length, and I also have the ability to understand. So there is no, someone
No
special
rocket
sitting.
science.
Yeah.
Okay.
So, but whereas this is the practice of the ground, and this is how it is going to manifest and is manifesting in some pockets at least. But two points worth considering here: that there is no change in the wording of the legislative statutory provisions on this. So that remains that when AO finds it, and they use the expression, if I'm right, necessary and expedient.
Right.
Right, when AO finds it necessary and expedient, and those are very powerful words. This connotes a very clear-headed decision making, seriousness, that you have found it necessary, and also not only having found it necessary, found it also expedient to give it to the TPO. That's one part. And if that is not change in law, then that would hold field, despite the instruction 3 or despite instruction 15.
Correct.
Right. But what begets a question is that when AO has to find whether it is necessary and expedient, does AO need a input, or can AO get an input from somebody else? And here I would bring to attention the point that the risk assessment of the tax scrutinies, both for transfer pricing and non-transfer pricing and other trends and deviations, there is a directorate which was created on the Directorate of Risk Assessment. The whole idea is that the Risk Assessment Directorate does at a central level the data crunching, analytics, etc., to find what are the cases which present a risk score higher than the others. Now consider a case that the Directorate of Risk Assessment as an organ within the Income Tax Department does this, and that is finds the risk score, sends it to the assessing officer. Assessing officer has very little visibility of what's the algorithm for the risk score. Now he gets a risk score which is high. For my case, he gets a risk score which is high. And the law says that he needs to find it necessary and expedient. could you then challenge that, look, he didn't find that risk score, it was given by somebody else,
Right.
and therefore it is violation of law, and he hasn't applied his independent mind, and therefore such a reference or such a adjustment in the transfer pricing is uncalled for. So to my mind, that's a kind of situation which would be a little far-fetched to say, because it's an assistance to the assessing officer for his decision making. You're not taking away his decision making. He can go back and challenge the Directorate of Risk Assessment to say, oh, by the way, you are saying this, but I don't agree because I do this assessment for 5 years, right? So that's one point, that we need to be cognizant. The law has not been amended on this. The statutory wordings remain same, and therefore we would need to be conducting, the AOs would need to be conducting both in fact and also in terms of evidence. And even today, when the reference is made, there is a mechanism that it goes to commissioner for approval, etc. That would continue. And to my mind, when that would continue, by virtue of, because of this decision, people would put little more meat and evidence on that than it perhaps is happening today. So it would get automatically regularized, so to say, for the subsequent cases. And even after the risk assessment becomes the basis for selection of cases, the same thing would need to continue. And we cannot be in a situation that because now it is risk assessment based, therefore this aspect is again given a go by.
So AO is, the power has shifted back to the AO in that sense. If we unless the law is amended to say
the power
otherwise.
was always with AO.
Yeah.
It is recognized and acknowledged now even by the court that it is with AO, and courts have rightly used or said that, look, it's the court who would need to decide where does the power reside in terms of reading the law, and not the board instruction.
Absolutely.
So we're seeing active change there, because they're saying that we will give you a show cause notice at the AO level. That this is the reason why I believe it is necessary and expedient. So tell me why not.
Okay.
So that is the expectation, but it might just be a one-line letter saying, I intend to send to TPO for review.
If you have any
objection, let me know.
Right.
Which is slightly different. So again, there will be legal interpretation of that at some stage, so that is not an application of mine. So those things will still continue.
Same like in 147 cases.
So that engagement is now happening, which was never there.
Okay. But I think the point that both you, Vijay, made, and Amitabh, you added, that this small activity, which we may just call an activity of AO, giving you a show cause, putting you at guard and writing you a letter which may be one-liner, etc., we are going down the same path as it happened in 148.
Yes.
Yeah.
Right. And I feel that the way the law is written today, the jurisprudence would develop similarly.
Correct.
And when it develops similarly, you could have a situation going forward that AO would need to give you the reason, you could object to that, and you can challenge that, etc.
And that becomes a appeal process
in itself, or at least the intervention process in itself.
Yeah.
That's number one. Number two is that the TPO's function, or the whole TPO organization within the tax department, is an specialist organization. Now, this being a specialist organization, to what extent, and again going back to the Supreme Court case in the Bharti's matter, where they said that for an specialist, you must consider that a specialist reasoning and a specialist basis and skill and knowledge to be used for determination of tax.
Yeah.
Now, if within the tax system the TPO isn't a specialist on that, and if then the AO, who is, so to say, without any disrespect, is not a specialist on that, and if he gives an opportunity to a taxpayer that, look, this is why I want to do that, would that be a reasonable opportunity, one? And would it serve any meaningful purpose? Right. And if it does not serve any purpose, then isn't it now the time to change that in the statute itself and move away from that requirement of AO having to find it, rather leave it to be found by your central team or by your risk management team to say that these are the cases to be taken up for scrutiny?
Yeah, as a transfer pricing person, I see transfer pricing shift into a legal battle than an economics battle.
Absolutely, which is unfortunate.
And which is unfortunate. And I think our whatever direct tax law, whatever that was coming out at some stage, that thought of a direct 3CB filing to the TPO initiating it, and not necessarily an AO initiating the process. So which means that then there's no necessary and expedient, and those kind of issues would have been by.
And an specialist dealing with the matter. So from that perspective, it is very good.
But isn't that the way it happens in, say, your firms also? If a client asks, say, Vijay, indirect tax issue, he may know it, but will he not refer that to a more specialist team.
Yeah, and it's not only the good practice or a management theory, it's also the mandate by a ruling from the court,
Right.
that even for determination of tax matters, we need to follow this discipline.
Right.
And therefore, as Vijay said, this is high time to my mind to look at the wording attaching this necessity and expediency determination by AO to be shifted out, and so make it more neat that here a specialist gets the data, here a specialist uses it and then confronts you on a show cause basis, and then you deal with it.
Right.
So let's see how this case goes on. But the other part, which is even more interesting, where they said that if there is no motivation of
To evade tax.
avoidance of tax, and because this is in chapter 10, which deals with avoidance of tax, if prima facie there is no mechanism or motivation or intention for avoidance of tax, then transfer pricing adjustment should not be made.
Correct.
So which
How much
again-
do you ascribe to?
No, so I think it again goes back to the same thing, that you need to find the cases where there is a risk, right? So if there is no risk of avoidance there, then it becomes academic whether or not transfer pricing applies. Even if it applies, you should choose not to select that case, and go ahead and select some case where the adjustment would be required and necessitated because there is an avoidance involved in that. And
So I think the issue is whether there is a saving by underpricing the transaction.
So
in a
just to
full tax
rephrase the
holiday.
question,
Yeah.
do you really think that the tribunal identified these two aspects correctly? That because the AE is in a higher tax jurisdiction, or because it's a tax exempt unit, there is no motivation, or there can be still some motivation to manipulate prices even in this kind of circumstance?
So really, transfer pricing is about giving the right reward for the right function. So in a way, if you get it wrong, but you end up paying higher taxes to the other jurisdiction, it's not necessarily correct. But the interpretation of this section or this court is on the basis of the way the law is written.
Yeah.
In principle, I would say that because you underpriced India and paid more taxes in the US doesn't mean that you are okay, you should be let go. Philosophically, it's wonderful,
Right.
but I think the essence of transfer pricing is a jurisdictional issue, so they need to protect their tax base. It should be fair to evaluate the right tax. So that per se should not be the answer, that because you're paid over excess taxes in a high tax jurisdiction, therefore there's no erosion of tax base. From a taxpayer point of view, that's true. That's possibly the way they look at it, that if I paid enough taxes, there should be no issue. But then from a jurisdiction point of view, it should still be available for them to look at. So I would think that the fact on no erosion of tax base is a valid point, but also has to be looked at in the context of whether I would have enjoyed a full tax holiday if I would have overpriced that transaction,
Right.
and or underpriced. Either way, it's tax neutral, then maybe it is irrelevant. That's what the High Court in the case of Vodafone said.
Right.
So they said that it's immaterial what you do, because whatever you do, it's not taxable. But here, that's not the fact, because if you were underpricing it, you have eroded at least the DDT part of it. I'm not sure about how TCS runs their business, but otherwise, if it's a typical inbound company, then you eroded the DDT at least by having lesser dividend to pay out. So that could be one erosion point to be considered. The other is that the law as a fiction provides that if there is an adjustment, that will be taxed. So yes, from an intent point of view, I don't have a particular intent to underprice because I'm on a tax holiday anyway, but I do end up with a consequence of tax, and therefore there is a tax collection by the revenue if I were to falter on my pricing. If I use the right pricing, I may have to pay some tax, which I'm not paying because of underpricing. So that could be another argument against whether this transaction itself is tax neutral or not.
And the issue, as Vijay said, and he illustrated it by erosion due to DDT, if you don't do the pricing of the transactions right, then it manifests in many manners, not only for income tax, but for other things, just the cash flow for a country as a whole, for economy as a whole. So it's a discipline in the Income Tax Act again, which is servicing not only the purpose for tax collection, which is also servicing the purpose that you are actually doing the transaction the way it ought to be done in a arm's length business environment.
Right.
And therefore that discipline, if you want to let that go away, because from a narrow income tax point of view, you don't find there is a erosion or there is a additional tax that's coming from it immediately. That may be a very narrow approach to deal with that, to my mind.
So there was this judgment, I think it was the Intera judgment, where I think the court said that, we really don't have to see whether the sum total of
These things
ALP should match the global.
Yeah, but we
profits.
have a Supreme Court which says that I have to look at the global.
You have to look at the
Yeah.
global.
So,
So
you
this
can't-
kind of read is similar.
It's similar.
It's
Similar. No, if you look at the earlier judgments, both in the Umirbai and Anglo-French, the Supreme Court said very clearly that yes, you could have the activities in multiple jurisdictions, and then you need to allocate, right? And the allocation and apportionment is a standard practice which has been recognized in tax law.
But 2 plus 2 can't be equal to 5.
2 plus 2 can't be equal to 5, because when you say, once you say you're allocating or you're apportioning, you're allocating or apportioning out of something, right? Then that allocation and apportionment can't be more than what you are allocating it from or out of. And therefore,
But the transfer pricing methodology
but
goes
due
against
respect
that.
to the Supreme Court, it is not necessary. Because when in transfer pricing, what we see is not a year on year. You could have a loss-making parent giving a contract manufacturing work to India, where India is expected to earn 15% margin, you operate on 2%. The 13 is incorrect, because as a risk bearer, he's ought to absorb the loss and you ought to have profit. You can't look at the sum total and say the end customer revenue is nil, so there can be no TP adjustment, which is what the Supreme Court has said, to say that ultimately it cannot exceed the overall revenue that the end customer is earning, which is not necessarily a year-on-year issue. So at times, the right answer in arm's length would have been a long-term thing. So you could still suffer. So yes, formulary apportionment would say you have to do it on a year-on-year basis, but transfer pricing would still say that you could have more than the overall profit. So it could be 2 plus 2, could be 5. And there are fact patterns where it's
so for
possible.
a particular year, 2 plus 2 could be 5, but on a long-term basis, once you complete the economic cycle, it won't be. Right. So therefore, the economic theory still prevails and is still underlying this. But when you do the cuts for years, you may have up here or down here, but even out on the economic cycle.
But we only, as a shareholder, people who live by quarter to quarter or year by year,
they live by week to week, news to news.
So we have Supreme Court, which says that you cannot exceed the overall profits of the enterprise as a whole.
Right.
So we live with that.
Okay. So that, I think, completes this discussion on the TCS judgment. And since we have already exceeded our time, I would like your permission to stop here. And the other topics, though important, were not as important as the three we discussed. And thank you for the wonderful insights and the lively discussion we had on this. I hope the two of you enjoyed it as much as I did. And I look forward to completing the topics and the discussions again in the near future. Thank you, Vijay, and thank you, Rahul.
Most welcome.
Thank you.
Thank you.
And hope to have you again on this forum soon.
Yes.
So on behalf of IFA Academy, I wish you all the best. Have a very nice day and enjoy your weekend.
And Happy New Year to you and your reviewers.
Thank you. Thank you. And all the best with all the litigation that both of you are actively pursuing. Thank you.
Thank you.